I'm a labor and employment lawyer. Been doing this for about 15 years. So I have that experience to draw on. I know you've already provided some questions for me in advance, which I'll address. So I'll start with the cannabis topic. So when the federal government indicated they were going to legalize cannabis, and the provinces would be able to address and regulate how it's sold and possessed, consumed, most labor and employment lawyers, I think we thought it would be regulated like alcohol is regulated. But the legislation we saw in Ontario, and every province is different in terms of how they address cannabis use. Every province is different, and in Ontario the legislation was much more restrictive than we had thought. So we were telling everybody, and I wrote a blog on it, that if you thought you were going to have pot brownies at the office holiday party, that's a no-no. Under the Act, if you contravened the Act, there were penalties, fines up to $5,000 per person, and many, many more thousands for corporations. So even if your culture, your office culture was a little non-mainstream, I'll say, and you permitted people to consume in the workplace, you would have been in big trouble. So I'm going to get into the next phase, which is that the law changed. So now there's no prohibition against it. Yeah, so with the new government, they changed the Act. They basically took all the regulation out of, so we have a Cannabis Act, and in that Act it said, you know, there's no consumption of marijuana in the workplace. And they completely scrapped it. And they said, we're going to treat cannabis like we treat tobacco. And we're going to regulate it along with the Smoke-Free Ontario Act. So in the Smoke-Free Ontario Act now, it's not just tobacco that it covers, but it also covers the consumption of cannabis. And it prohibits the smoking or the holding lighted cannabis only in enclosed workplaces, okay? So what's prohibited, what's illegal to do in the workplace? Smoking cannabis or holding lighted cannabis, okay? In an enclosed workspace. So what's an enclosed workplace? It's a place, structure, vehicle, etc. that is covered by a roof and is not a private dwelling. So if you're in a building like this, illegal to smoke cannabis if you're in a workplace. Okay? If you're on the job here, let's say you're a groundskeeper here, you're outside, or you're just taking a break, it wouldn't be illegal to smoke cannabis outside as long as you're not under a covered roof. So if you're under the gazebo, you're going to be in trouble. Okay? It is interesting.
I'm actually the VP of HR for IO and CBY. In our policy, we actually indicate you cannot smoke on our premises, and that includes parking lot and parameters, right? So we've been very clear.
Yeah, you can do that. I'll get to that piece about policies. Maybe we can hold the questions till after I get through the cannabis piece, because there'll probably be a lot of questions. I want to make sure I get through the material, and then I also want to hit the employment standards changes, which are also important. But policies, absolutely, that's what I'm going to get to. So it's illegal to smoke cannabis in an enclosed workplace, but it's not illegal to otherwise consume cannabis. So you could ingest cannabis or whatever else, however else you may take the drug. It wouldn't be illegal to do that in the workplace. That doesn't, and sorry, just to go back here, I emphasize the fact that it doesn't apply to a private dwelling. Under the old legislation, there was a question about, you know, people that work from home and whether that workplace would be covered. So would it be illegal to do that in your own home? And now the answer clearly is no, because they have the exception right in the Act. So the government can't come into your home if you're using it as a workplace and tell you what to do, basically. Now, we're talking about whether the consuming cannabis in the workplace is legal or not. There's, of course, a contractual relationship between an employee and an employer, which is completely apart from what's illegal. So when I'm talking about what's illegal and illegal in the Act, that means you're not going to get a fine, you know, or have a record of some sort. But there can, of course, be consequences for consuming and being impaired in the workplace, obviously. And I mean, it just comes down to the fact that as an employer, you're not paying for 40% or 60% of someone's brain, you're paying for 100% of it. As well, when I say, it's not illegal, that's a general statement because it can be illegal if you have employees in a safety-sensitive position. So if you have an industrial workplace where you have heavy machinery or people driving vehicles, a worker can certainly be charged and fined and imprisoned if they cause a hazard for another employee, whether they're hurt or not. So in an office environment, you can see not a problem, but in an industrial workplace, you're going to get into the Occupational Health and Safety Act, which would make it illegal to create a hazard for other people, other employees, managers, and so on. So although not illegal, you need to think about, as an employer, what you're going to do about cannabis. So previously, people had said, including labor and employment lawyers, we're all about making you draft policies, and some people thought, well, if it's illegal, do we really need a policy, or is it that urgent? Because if I have an employee doing something illegal in the workplace, it's going to be a lot easier for me to justify a suspension or a termination, okay? When an employee does something illegal, that gives you a lot more latitude. But for now, a substance that's not illegal in the workplace, and it's similar to alcohol, what do we do? So I'm going to tell you now it's an important time to implement a drug and alcohol use policy if you don't already have one. Besides cannabis, there are also illegal drugs. You may also want to have a policy about alcohol. And these questions really come down to your business culture, okay? As an employer, you have the right to control your workplace and what your employees do in terms of being impaired in the workplace or at work functions. And some employers absolutely prohibit the consumption of alcohol at work events, and they're entitled to do that. They can do the same with cannabis if they wish. Or if they're more liberal, they can allow you to consume, employees, as long as it's safe, cannabis in the workplace. Along with policies, of course, there are practices in the workplace. So, just because, an employer or our manager frowns upon it, you don't want to be in a position where you have an employee who is impaired in the workplace because they smoked cannabis at lunch or consumed it in some other way, and their defense is, I know the manager on the other team does it all the time, and this other person does it, and so on. So two important reasons to have a policy. They'll be, the employees themselves will be less likely to say, well, it's part of our culture or part of the practice in the workplace, or you turn a blind eye to it. And the second thing is, it gives fair warning to the employees about what's permitted in the workplace or not, and what the consequences of breaching the policy are. And as a labor and employment lawyer, when you have a problem in the workplace with an employee and you're trying to manage that, whether it's to the point of terminating the employee, having a policy in place that's clear and that's been given to the employees and they know about it, really helps me to do my job when I'm giving you advice and defending any position that we might take. So, key ingredients of a workplace policy. First, you want a policy statement. And this, I think, will reflect, what your company values are, what you see as being permissible in the workplace or at work functions. And you want to address not just consumption, but you may want to address possession as well. Some employers do not want marijuana in the workplace at all. And if they want to ever be able to enforce that had better be in a policy. Because it's really no different than going out at lunchtime and purchasing a bottle of wine that you're going to consume after work, right? So if you want to treat marijuana differently, you'd better have it in a policy. And then the application. So what does your policy apply to? It should apply to all drugs, including cannabis, and it's also a good time to address alcohol, because whenever you have employees that are impaired, I mean, this is most of the time this happens at work functions when people are drinking alcohol, or these days, may be taking drugs, and in the past may have been taking illegal drugs. There's a liability that attaches to your organization. And to some point, most businesses are willing to accept, a small risk. If they let people consume alcohol at the office party, you tell them they can't consume too much, and you give them a taxi ride home at the end of the night. So it's a good time for to have a policy that addresses alcohol and drugs. Really, and I say this after looking at the case law and what the courts will do in situations. Where employees have been suspended or disciplined or fired, and then they sue the employer and say, no, you didn't have a right to sue me and not give me a severance package or offer me, a pittance. I was entitled to a full severance package. And the courts are pretty clear that if you're going to fire someone, especially for cause, and not give them a severance package, you'd better have a really good reason. As a labor and employment lawyer, I get questions all the time and scenarios thrown at me, and employers thinking, I must be able to fire this person, right, and not give them the severance package. 9 times out of 10, I tell them no. 9 times out of 10, the answer is no, you can't do that. 1 time out of 10, I probably talk about some risk. You know what? We're in a gray zone probably where you could fire for cause, but there's some risk to doing that. And once in a blue moon, I tell an employer if it's a case, especially of theft or breach of trust or conflict of interest, those are the clear-cut cases where you can fire for cause. So the courts, what they're really going to look at is impairment. Okay, that's the most important thing. I'm not saying it's the only thing. If you have a policy against consuming alcohol or cannabis in the workplace, you're going to be able to enforce that. It's just if an employee breaches that policy for the first time, can you fire them right away? The answer is likely no. So if you have a policy that sets out the fact that what you're concerned about is impairment, which is the most important thing, because in this contract you're paying for this employee's brain most of the time. I mean, some labor jobs still, but most of the time it's knowledge and know-how. So if we can focus our policy on impairment, and that impairment in the workplace won't be tolerated, that's the strongest statement we can make in a policy like this. What we do need to do, and I mentioned here at point number 4, is we need to make sure that we carve out a place for employees who need to take drugs for medical reasons. Okay, and this again is, as I said at the beginning, a lot of what we're reviewing here today, is not that new, because we have had it. I mean, we do have alcohol, and it's been around for a long time. It does impair people, and we do allow them to consume it in the workplace at work functions. And cannabis is not that different. As well, we of course have employees who are taking legal drugs for medical reasons that impairs them, like opioids, okay, or antidepressants, or any of those kinds of medicines. So we need to make sure this policy is not simply, zero tolerance. If you're impaired in the workplace, you're out. We need to have a section that talks about an employee's right to consume medicinal drugs, right? And it's not going to trigger the policy. One of the things I like to put in the policy, and it's a bit of a, can be a bit of a touchy subject, having an employee tell you about their medical problems. But in the policy, I think you can have a clause that says, if you're taking a drug that's going to impair you in the workplace, we need to know about it. We need to know if you're impaired at all. And we'll work with you to address how we can accommodate you, and that may be a short communication between you and the employee's physician, but it doesn't have to be that. I mean, depending on the situation, it may be a quick conversation with the employee, and you move on from there.
I know you said no questions. I can help myself. So number 5, carving out for drinking and driving. Is it not the same now for being impaired in driving using
Absolutely. Yeah. I mean, certainly if you are offering cannabis at a workplace function, which is now possible, okay, just like alcohol, you don't want that. You don't want any employee leaving the workplace and driving a vehicle, because that creates a big risk for you as an organization. And I'll say the final ingredient in a cannabis policy is to make sure it's clear what the consequences are for breaching the policy. You might have heard about last chance agreements. So, you know, when you have an employee, you're managing their conduct and performance over a long time, and they have problems. Not typically used for performance issues, but when you have other behavioral issues, absences, and you know, when you have a last chance agreement, you and the employee sit down and you agree, you know, there's been a problem. The employee says they're going to fix it, and you tell the employee, this is your last chance. You know, I'm not going to fire you today, but you're going to sign this paper, and I'm going to give you one more chance. They're not always determinative. A court's not always going to say, yeah, you know what, you can fire this employee, but it helps you. Okay, so same thing as having a policy. If in the policy it's clear to the employee, if you consume cannabis at work or impaired at work, you know, we have no tolerance for that, or if you're impaired at work, we have no tolerance. And the consequences are, by the way, discipline up to and including termination for cause. Then it's easier later to defend yourself, to say, you know, this wasn't part of our culture. You know, we were pretty clear. You know, while, you know, these things may be legal, we had zero tolerance for impairment in the workplace or for consuming these things in the workplace, and the employee knew about it. Okay? The worst thing you know, you want as an employee to say, well, I didn't know I was going to get fired for this. You know, this substance became legal now. We have drinks at the office party. Why couldn't I have a pot brownie, you know, at the end of the day on a Friday? I see some people go out for drinks. So the last thing I'd say, yes?
Just a quick question about impairment. Is there a rigorous definition for impairment? I know alcohol 0.08, I think, is a measurable, but for cannabis consumption, is there something similar?
Right. Even for alcohol in the workplace, you're not going to be able to tell someone's blood alcohol level. Same 0.08, right? I mean, that's a criminal matter. But there are other things that, you know, just like, you know, if you have an employee at work who's, you know, drinking on the job, you're going to notice things about their behavior. You're going to notice, you know, other things in terms of their work product. And so when you do have a policy, I do recommend you having a definition of impairment. And it would include things like, you know, not being able to have work product that's acceptable in the circumstances, not being able to meet deadlines, behavior that can prejudice or create risk for the company, behavior that can cause reputational damage to the company. So those would be the big things that you're worried about when it comes to impairment. But you're not going to have any black and white rule. You know, you can't test their blood or their saliva, for example. So the last thing I'd say on cannabis, before we move into questions, the big thing I'll say when I get a call or an email from an employer who's got an employee that's abusing some substance or they're impaired in the workplace is I urge restraint. And it's funny how sometimes I get a call, and this happens regularly, where an employer is certain that an employee is impaired or they have evidence that the employee was consuming during work hours. And when you drill down and I ask more and more questions, who was it? You know, okay, can you get a statement from that person in writing? When you push and push and push, you know, I'd say 3/4 of the time, that evidence is either non-existent or pretty weak. So I'd urge you to do the same thing if you have a problem employee who you think is impaired in the workplace or consuming substances in the workplace, and it's against your policy, that you do show some restraint at first and make sure you have all the evidence before you go ahead and move on that. I can tell you if you go to court where the evidence is not clear, the court is always going to err on the side of the employee if the evidence is not clear. So that's what I have on so that's the cannabis update. You know, big changes in the law. Previously was illegal. now isn't illegal to consume in the workplace unless you're smoking it under a roof. And you do need policies. A lot of this hasn't changed in terms of how we address it in the workplace, because we're already addressing alcohol in the workplace. We've already been addressing the consumption of marijuana in the workplace. Just because it was illegal before doesn't mean it didn't happen. A lot of employers were worried about, how are they going to manage this? How can they tell if someone's impaired? I can tell you that since October 17th, I've had very few inquiries, where employers want to talk to me about a problem employee. Very, very few. So things haven't really changed that much, other than, going forward, there's some added risk because cannabis is now legal, and the best way to protect yourself is to have a policy in place covering those areas. So, questions? Yes?
We have a lot of employees who travel to the US. Obviously, they're not bringing cannabis, but in conversation with customs, what's the appropriate thing to say?
So that's not my area of expertise. I do labor and employment law. So the question was from an employer who has employees that travel across the U.S. border, and what we should be telling the U.S. border agents, the scary U.S. border agents. The government of Canada has issued guidelines on it. They say don't lie. I think lying can get you into more trouble. And we don't know whether they're going to seize your cell phone at the border, which they can do, and search it. And if they see you've got a purchase from the Ontario Cannabis Store and you lied to them, you could be in more trouble. Again, not my area of expertise, but that's if I were helping an employer draft a policy on this, that would, getting kicked out of the U.S. for lying is probably worse than getting kicked out because you've admitted you smoked marijuana in a country where it's legal. Sorry, not my area of expertise, but that would be my thought on it. An immigration lawyer would be the best person probably, because they're the ones that deal with what happens after the fact once you've been banned from the U.S. And yeah. Yes.
So if you suspect an employee to be under the influence and you approach them and you say, I think you're high, are you using marijuana right now? They say no. What else, you smell like marijuana, your eyes are a little bit glazy, your work is impaired. Like if they say no, what really can I do at that point?
So the employee tells you they were sprayed by a skunk in the morning. There's still a residual smell, and they were in the wind, so their eyes are bloodshot. Sometimes those things happen. So what's important is, as I said before, is to restrain yourself a bit in terms of just firing the employee. If you want to do that, okay, we better have clear evidence. If you want to move forward and fire an employee, not give them a severance package, if that's what you want to do, which is what most employers want to do in that situation, we better have some clear evidence. So, on that occasion, the first occasion it comes up, you have the conversation with the employee. If it's only the employee, there's no other witnesses around, and the employee says, no, I haven't, I'd say then you're into, a period of time where you're going to observe the employee for similar behavior. And if it happens again, you say, okay, this is the second time, in a week where you appear this way and your behavior is different, tell me why. It's always important to let the employee explain themselves. Okay, they may tell you they have some kind of medical condition that's, making them off kilter, in terms of their gait, if that's what you observed, and then look at their work product. Right, a good way to see if an employee is impaired is to give them work to do. Right, give the employee work to do and see what happens. If you have that added piece of evidence in addition to these other things that you're seeing over time, you can put I'll call it an evidentiary record together until a point where you call me or some other employment lawyer and we say, okay, we need to talk about this case. This is what I've witnessed so far, and this is what I have in writing, and this is what other employees have observed. And I got them to send me an email telling me, what they saw. So I would say in that case, on the very first time you see an employee in that situation, it's not a time to say you're fired, get out of here.
No, not so much. I wasn't thinking so much, hey, you're fired. But
Yeah.
more like,
How do you manage it?
yeah, exactly.
Yeah.
We work in a business where we operate, small amusement attractions. And if I say, hey, Donna, are you what
Right.
are my kind of rights if I feel, whether he's drunk or high or whatever it is, can I say, sorry, something's off, like, you gotta go, other people's safety's at risk right now.
Yeah, right. Even if there's something legitimate in that case, you see employees stumbling a little bit at work, even if they have an explanation, there's some medical condition, that's still a safety issue for you. So you talk to the employee, send them home, and then you figure out what you're going to do about the situation. But safety obviously comes first. What I was explaining is, if you want to manage the situation such that at some point down the road you want to fire this employee for cause and not have to pay them a severance package, right? Which is what most employers who have employees who are abusing drugs or alcohol in the workplace want to do. And some employers just, they'll just get rid of them and pay them a severance package and off they go. Most of the time that's okay, unless the employee can say they have an addiction and then they fall under the Human Rights Code. And we could have a whole other seminar on that piece. So that gets a little bit complicated. Any other questions on cannabis?
Just like alcohol, I know there is something like a breathalyzer to test the volume or content of alcohol in your body through your breath. So I don't know, is there anything like that that you can use to check cannabis?
The vast majority of employers would not be able to use such technology because it would be an invasion of privacy. The only employers that are going to be able to use that kind of technology would be people that work in very safety-sensitive positions. So if you're working on oil rigs or at nuclear power plants or something like that. Even in that case, they're going to have a hard time justifying it when an employer or a union brings a grievance or sues the employer. Again, I don't have any expertise on that, but I mean the last thing I saw in the news, I'm pretty sure, said that even the police forces still can't, aren't sure the technology is appropriate, and that criminals are going to be able to defend themselves pretty easily when they start poking at the technology behind the evaluation equipment. So that won't be part of your set of tools when you're assessing employees and you suspect someone is impaired in the workplace. That will not be one of your tools unless you're working at a nuclear power plant and you have problems there, probably. Okay, I did have a list of other questions that people provided in advance. So the first one is, number one thing we need to know about accommodating medical marijuana in the workplace, and how far does this duty to accommodate extend? If you've ever dealt with accommodation in the workplace, it's tricky and it needs to be managed well. If you have an employee that says, I need to take marijuana for a medical issue, I mean, for the most part, an employer is not entitled to an employee's medical records or medical information. But when an employee comes to you and says, I need to be accommodated, okay, because I have a certain health issue and I have certain functional limitations and I need to take a certain drug that impairs me, that opens the door to letting you, ask some questions of that employee and their physician. I mean, in a lot of cases, you can manage it, without going down that road. But in some cases, you may have some serious concerns that an employee who's impaired, for example, can be your editor-in-chief. Now, who's the person that's going to tell us whether the employee can do that job or not? Whether they can function at that level to be your editor-in-chief? Who's the one person you think has that expertise? Their family doctor, right? Their treating physician, right? That's the only person. The person who prescribed the medication is the only person who can tell you whether that person can function in that job. So, I mean, I'll get some inquiries from employers where they have received a note that requires a duty to accommodate. It may not be because they're taking certain drugs, but in this case they are, and they think they're stuck with it. And they say, Jim, it's completely unworkable. The doctor doesn't know what this employee does, or doesn't appreciate the impact it's having. The first thing I'll say is the obligation on employers to accommodate employees is very high. It's to the point of undue hardship, which means that even if it hurts you a little bit or it hurts you a fair bit, that's okay. That's what the law expects. Okay? But if it hurts you a lot, that's when we can say, sorry, you know what, we don't have to go that far. So to go back, if we have an employee who brings you in a medical note that says I need to be accommodated, I need to take medical marijuana, you know, the first thing you might say is, well, let's try it and see if we can do it. Let's see if this will work. And if you're really skeptical and the doctor said, you know, this person could do this job, maybe it's then time to get the physician in the conversation. So what I would recommend is you need the employee's consent. Okay, if you don't get the employee's consent, that can be a problem for the employee. But once you have the employee's consent, you write a letter to the doctor setting out this is what this employee does. Okay, we've tried this accommodation measure. The employee, you know, is apparently taking this medication. This is what we're observing here, and the work product is, you know, what it is. Okay, it's not appropriate. You know, the employee can't do the job. And then you wait to see what the response is from the physician. In that case, usually it's a good idea to have a lawyer give you some guidance over what to do there. But it may be that the doctor says, you know what, this employee's so sick they need to be on medical leave. Okay, doctor now appreciates what the employee does. It's not working. Maybe they change the medication. That's a possibility as well, which we'd have to work through. But maybe they say this employee needs to be off on a medical leave. So maybe you have benefits, you know, short-term disability or long-term disability. And if not, they could probably get employment insurance for the 17 weeks or so. Not so much your issue if the doctor puts them off. That's up to the employee. Okay, this question we've already answered. Okay, in regards to our travel and entertainment policies, we have always made reference to alcohol. Should we be including marijuana and other cannabis-based products now? Absolutely. You know, it's a good idea to have a policy on both alcohol and drug use. Last one is we have traditionally blocked cannabis-related websites so employees could not access them from work. We would prefer to keep these blocked as we would rather our employees review these at home on their own networks. Is this still a good practice? Sure. As I said before, you determine what your workplace culture is, and if you don't want cannabis or alcohol in your workplace at all, okay, that's something you can do. You have control over your workplace and what your employees do in the workplace. So if you've blocked those websites, you know, it may be annoying for some of the employees, but if that's your prerogative, then by all means an employer can do that. So that's all I have for this list of questions. Anything else? Yes?
It's a bit of a special case, but what about professional athletes? You know, they get tested for drugs, and I see some similarities between what they've been through and what employees may be going through. Has that been an issue at all?
Not an issue. That would be it would be a very special case because to get to that extent in a workplace, again, you'd have to be in a workplace where there are very serious physical hazards, okay, like a nuclear power plant or an oil rig or something. But in some of those workplaces, and certainly ones that have problems, they can get into the testing phase and they can get into trouble. Absolutely. Yes. Correct.
But if you, as an employer, you're allowed to have this policy barring drug use. But is it like, are you allowed to allow it? Is that, I mean, that's a good question. Like, are you allowed to have pot brownies at your company function?
If your employer, yes, if your employer sanctions it. So the question is, you know, can you have pot brownies at a work function? If your employer sanctions it, yes, you can. Yeah, just like you can have alcohol at a work function. As I said before, so you know, for a year and probably more, you were bombarded with ads from the Ontario government that said, you know, smoking pot in the workplace is illegal, and you know, a lot of other things. And this law basically changed, I think, right on the doorstep of October 17th, maybe the day of that the legislation changed. And so, I mean, like I said before, not much has changed since October 17th, but it is a new reality, and it's a good time to, you know, to think about what's now permissible in the workplace. And you know, we should have a policy in place that makes it clear for employees. Just like you have questions here, you know, as an employer, you want to make sure your employees understand where you stand on these things. It's not as simple as saying that's illegal, you're in big trouble. You know, come down to my office anymore. Okay. let's go. So if everyone's okay with cannabis, I'll move on to the Employment Standards Act update. So as I mentioned at the beginning, this is the other big, big change this year in labor and employment law. The Employment Standards Act was basically the same for 2 decades. Almost every single thing in the act, 90% of it hadn't changed. And last year, we had significant changes that were enacted, which came into force this year on January 1. As of January 1, 2019, a lot of those changes are going to be repealed. Okay, so we're mostly going back to what the Employment Standards Act said before. But right now, today, those amendments on January 1 are still in place. And as I say here, this is not an exhaustive summary, but really just the main highlights. So the first one is minimum wage. This was a big political topic about whether $15 an hour as a minimum wage was appropriate or not. The current government seemed to say that $15 wasn't a problem, but we're going to push it off in the future. So we thought that the law would change in the sense that instead of $15 an hour January 1, 2019, maybe it happened in 2020 or 2022 or something. But what happened is that's been completely taken out of the act. They haven't rolled back the $14 an hour minimum wage, so that will stay. And that will stay in place until October 1, 2020. So the minimum wage stays at $14 an hour until October 1, 2020, and then it increases by the Consumer Price Index, which is basically tied to inflation. So if inflation's around 2%, that's pretty much how it will increase. So under the current government, for the next 4 years, we're not likely to see much of a move at all in the minimum wage. Public holiday pay. I don't know if anyone in this room has had a problem with public holiday pay since the new changes came into force. This was one that a lot of HR professionals were making a lot of noise about because they changed the definition. Previously it was the earnings in the last pay period divided by the number of days worked. Okay, so January 1, 2018, we got a new definition for public holiday pay. So everyone knows what that means, right? So on Canada Day or Christmas Day, holiday, what do you get paid? So it was the previous earnings in the last pay period divided by the number of days worked. That was the new definition earlier this year. Caused a lot of problems. I didn't realize how many problems it caused until I had an employer client call me. They had an employee who works on commission. This employee made $60,000 a year. During the last pay period, okay, the employee worked on a day that the employee hit a threshold for commissions, and $20,000 in commission payments became payable to the employee. Okay, so I thought, okay, that's going to be an expensive public holiday pay because you take the amount of money earned during the last pay period divided by the number of days worked. And then the response was, well, Jim, it gets worse. The employee was on vacation for 9 days out of 10. They worked 1 day. So you take the amount of money earned over $20,000 divided by 1 is $20,000. So I knew it was an absurd result, and I tried to work with the employer to think of a way, that we could justify not paying that amount. And I said, the way the new change to the act is worded, I think that's what you're on the hook for. And I said, but I think the least risk here is you pay it. I know it sounds absurd, but call the Ministry of Labor and see what they tell you, because at the end of the day, they're probably the ones that will issue the order and penalties. And the Ministry of Labor told them they had to pay $20-something thousand to an employee on, I think it might have been Victoria Day weekend or something like that. So governments don't usually move very fast when it comes to legislation, but there was such an outcry over that one that on July 1st this year, they changed the definition back to the old definition, which was the wages earned in the previous 4 weeks divided by 20, which is usually the number of days you work in a 4-week period. What they did, though, is they put a time limit on it. Previous government wanted us to dig into public holiday pay and think about all the policy reasons behind it and what should we do about it. And so that definition would have expired next year at some point, in which case the old definition would have come back, the problematic one. This government basically said, we're just going back to the old definition. No one seemed to have a problem with it before. It wasn't a problem. Let's just go back to that definition. So that's what we're at now. So public holiday pay, wages earned in the last 4 weeks divided by 20.
And that, sorry, that changes Jan 1, right?
Yeah, well, that's actually, the previous government changed it July 1 to that same definition, so it won't change. So we're okay right now. We have a more reasonable definition now. Right, so from January 1 until July 1 last year, we had the absurd definition. On July 1, the previous government changed it, but it was time limited until we get into what we want to do with this legal right. The new government said, forget about all this. We're just going back to the old definition, which wasn't problematic. Okay, so you take the last 4 weeks of pay and divide it by 20, which would have still been expensive for that client of mine who got the $20,000 commission, right, payment, but not nearly as bad as paying $20,000. Okay, equal pay for equal work. So we have a Pay Equity Act in Ontario, which tries to make sure that males and females are paid about the same. That's more of a systemic law. Okay, so you go in and you look at classes of employees, and if a male class is being paid more than a female class of employees, then we have to equalize that and make sure everyone's being paid fairly. But we've always had as well in the Employment Standards Act an equal pay for equal work provision. And it basically lets any female in a workplace who's in a group of employees and thinks a male is being paid more complain about it, and if the employer doesn't do something about it, get an order from the Minister of Labor to fix it. It's not a systemic issue; it's just a one-off issue. Again, Pay Equity Act is more systemic. We're looking at all classes of employees and equalizing things, big mathematical calculations being done. So and that's how you may know about the old equal pay for equal work provision. What the old government did was they also added employment status to that provision. So not just between the genders in the workplace, but between people with different employment statuses. So if you're a full-time employee, okay, making $40 an hour, and your friend is a part-time employee making $30 an hour for the same work, that part-time employee could make a complaint and say, I want to be paid $40 an hour like my full-time friend. And this is something that employers do regularly, is that your full-time workers, right, and your permanent workers, you tend to pay them more and give them more benefits and that kind of thing. And people that are part-time or casual or term employees, you don't feel like you need to pay them as much. As the same level of loyalty is not there. So this government said, sorry, if you're a part-time employee or if you're a contract employee, you're going to be paid as the same person, person in the workplace who's doing the same job as you, you're going to get paid the same amount as them. Funny little issue, and so to get to the bottom of it, that was completely repealed. So you don't need to worry about paying your part-time employees differently from your full-time employees, or your contract or casuals different from your full-times. That's been completely repealed. One little issue that did come up in my practice was, a lot of times, you have people that retire and they want to come back and do contract work or part-time work, and it's usually a win-win because the retired employee gets something to do and gets some extra money, and the employer doesn't have to pay them as much, right? You work at a different arrangement, and you don't have to keep up, keep up the pay advances and that kind of thing. So that's one place in particular that I saw a problem. So that's now repealed, so we don't need to worry about that. Leave entitlement. So this is a big one. So there is a big change with leave entitlement. It's not gone back to the old act. As of January 1, 2018, you might remember the new law says, and this is still in place today, under the Employment Standards Act, you get 10 paid days of personal emergency leave. So when you're sick or you have a child or parent or other relative who's sick or needs help, you're entitled to 10 days off per year. The new government, or should I say the old government, required that the first 2 days of personal emergency leave be paid. So at the beginning of the year, if you start as an employee on January 1, and on January 27 and 28, you're off sick, this year anyway, you'd have to get paid for those 2 days. Days 3 to 10, you didn't have to pay for. You may have more generous policies than that at work. A lot of employers do. But that was a big one that a lot of employers, especially small employers, complained about because, you know, adding two sick days for all of your employees, I mean, that quickly adds up. So the new government, they changed that section altogether. So those standards have completely changed. Instead of having 10 personal emergency days, you now have 8 days in total. You have 3 personal emergency days, 3 days of family responsibility leave, and 2 days of bereavement leave. So instead of letting employees just, you know, call it personal emergency leave, you got 10 days to use for all those things, the current government has said you get 3 sick days, basically. We call them personal emergency leave days. 3 family responsibility leave days and 2 bereavement leave days. None of it is paid. Okay, so no more. You don't have to pay employees anymore for that, unless you've got a policy or contract that's more generous. The second note here as well, the prohibition against asking for doctor's notes has been repealed. So this year you couldn't ask for a doctor's note, and up until the end of the year, you can't ask for a doctor's note from a sick employee, at least until they've run through their 10 Employment Standards Act personal emergency leave days. So that's gone, and so if you feel like asking for a sick note after a day or 2 of leave, you have that ability. And if you're at all familiar with the list of family members, you know, where you can take a day off, you know, for family medical leave or bereavement leave, it's a big list. It includes just about everyone you could think of, aunts, uncles, in-laws, and everything else. So that list, the government didn't change the list of family members. There was also a new leave added, and the current government didn't change that, and that's for victims of sexual and domestic violence. So those people do get a number of weeks of leave, the first 5 days of which have to be paid. So the only paid leave in the Employment Standards Act is for a victim of sexual or domestic violence, and the first 5 days had to be paid. I can say that I have not. So we're almost in the full year, and I haven't had an employer ask me about this leave yet. Scheduling requirements. So this has been repealed, but I'll go through it just to see, in case you were worried about it. Employers that have employees on schedule. So I mean, if your place is just a regular Monday to Friday 9 to 5 shop, maybe this wasn't so much a concern for you. But we did have a lot of scheduling changes that were supposed to come into force on January 1, 2019. Well, actually, the first one on the list here would affect everybody, and that was you had to put in place a process for employees to be able to ask for a change of their schedule or a change of their work location. It didn't say anything about what you had to do about it, but you had to have a process for employees to ask for those changes. You had to consider it. You had to, send them an email or give them something in writing. My recommendation was to do it in writing just to prove you've done it, with a reason why if you couldn't make the change happen. So not much teeth in it, but it added another process that employers had to go through. That's been thrown out. So you don't need to worry about that anymore. If an employee asks for to work in a different office or change their schedule, you can just say no and forget about it. If you had employees on call, if you're that kind of business, the employees on call, the changes that were supposed to come into force were going to be expensive, because if you had an employee on call, whether they come in or not, they were entitled to 3 hours of pay. I had a client who had employees on call every single day, and they told me, they came in maybe twice a year, and they were pretty upset that they're going to have to now pay 3 hours to an employee for 365 days a year, basically. So that's out the window. Don't need to worry about that one. There was also a new right to refuse a shift if the employer didn't give you notice within 96 hours. So if you have a workplace with a lot of shift work, this would have been relevant, and you'd have to have your scheduling done, in advance, pretty much, in order to make an employee come into work. And there's also a change that if you canceled the shift with less than 48 hours, you had to pay 3 hours to the employee. So obviously, this whole scheduling regime was very employee-friendly. The government's basically, wiped all that out. So as of January 1, you don't need to worry about that stuff coming into force. The one thing that does remain is the 3-hour rule. which says if an employee presents at work, okay, so the employee's in the workplace, they're already at work. This is not you canceled the day before, the hour before. They're in the workplace. They regularly work more than 3 hours, so they're supposed to work more than 3 hours that day, or 3 or more hours, and the employee is available and willing to work longer, and you cancel the shift, okay, you tell them to go home, you've got to pay them for at least 3 hours. But this is the employee has come to the workplace, not that you told them the night before or the day before. The misclassification of employees. So this provision remains mostly in force. It's a really important one, especially for smaller businesses and new businesses, because in a lot of those cases, and this is where I see employers tripping up a lot, you're treating people as contractors when really they should be employees. And this has always been a problem. It's a problem from CRA's perspective, because CRA expects you to take their income tax, CPP, EI, health tax, and the courts as well. And why are the courts worried, or why do they get into it? What happens when you have someone who you're treating as a contractor, get fired? What does anyone who gets fired want? They want a severance package, and they want to get their employment insurance. So you have an employee, someone says to the other, let's not be worried about the paperwork, and this is great for our taxes. Okay, we'll set us up as a contracting relationship, but then that breaks down. And the person who's the employer is going to get a letter from this person's lawyer or a claim from them saying, my client was really an employee. You treated them as a contractor, illegal. You're going to pay the severance package, and you're going to pay them in lieu of the EI they were supposed to get because you didn't contribute on their behalf. So that's where we see it a lot. As of January 1 this year, the Ministry of Labor was able to come into your workplace and, like they always do, they can do an audit anytime they want. But if they're also in the workplace for something else, they now have the power to dig into the relationships. And if you're treating someone as a contractor who should be an employee, there are penalties for that. The only thing that's changed here is there was a reverse onus on employers. So an employer had to prove that this person wasn't an employee. Okay. Now it's switched back to the regular rule, which is if you claim something, you've got to prove it yourself. So now it's back to the employee. The employee says, if this person, the service provider, says they're an employee, that person's got to prove that they were in fact an employee. There isn't really a hard and fast rule to this. It's really, does this person operate like my plumber does, right? Who comes in and does a quick project and leaves again. The plumber has a business. They have a website. They have business cards, right? They have more than one client. I don't tell them what to do because I don't know anything about plumbing. That's why I'm calling them in, right? That's one side of the spectrum, clear-cut case. The closer this service provider looks like your plumber coming in, right, the less you got to worry about. The more it looks like this person is an employee, and if you had an employee in their workplace, they could do the same thing. You're controlling their hours. They don't have any other clients. They work for you exclusively for you. This person then starts to look more like an employee, and that's where you're going to get in trouble. So previously, before January 1 this year, we didn't have the Ministry of Labor on our backs. We had risk from the service provider saying they were going to be an employee, and from CRA, of course, who can audit things, and the employee can tell CRA, and that gets everyone in trouble. But now we've got the added complication of the Ministry of Labor digging into these relationships, and if they also find that someone should have been treated as an employee, there are penalties for that. It's not clear to us yet whether the Ministry of Labor is alerting CRA about it. We don't know, but it's reasonable to assume that that's going to happen. It may be in the employee's best interest anyway that something happens when they get found to be an employee. Employer has to pay employment insurance, and then the employee gets some employment insurance benefits. So what's not changing? The new vacation scheme is staying the same. So once an employee has 5 years of service, they're then entitled to at least three weeks of vacation. There was some, I'll say, misunderstanding about whether the employee isn't like at the 5th anniversary, or is the employee on that date entitled to 3 weeks, or is it that on the 5th anniversary they start accruing 3 weeks? It's that on the 5th anniversary they're entitled to 3 weeks. So if you want to look at it this way, in the 5th year, so from the 4th anniversary to the 5th anniversary, they start accruing 3 weeks, provided that they're still working on their 5th anniversary date. So that stays the same. We were wondering if that was going to change. There wasn't much politically said about the vacation piece. A little more expensive for employers for sure, but nothing changed there. And then other challenges, in terms of an ESA update, employers went ahead and changed their policies and their contracts. It's because things are going to change on January 1, are going to revert back to some of the old ways of looking at things, especially the personal emergency leave piece. So if you've got policies on personal emergency leave, you may want to have a look at those to make sure they're not outside the law. You may have given employees some better entitlements in your contracts, because now we've got to pay. We have 2 paid days. If those went into a contract, you can't just pull them back if you've contractually told your employee that they're going to get them. So we do have some challenges in this transition zone when it comes to policies and contracts. So that's the update. Any questions on the ESA? This topic's not quite as sexy as cannabis, so I know. I think I had a couple questions here that you guys came up with earlier. What is the best way to communicate the new ESA changes? You don't have any obligation as an employer to tell your employee their rights, other than the ministry requires you to post a poster in an area of the workplace where employees are going to see it. So that's your only obligation there, is to put that poster in place. Otherwise, you don't have to tell employees what their rights are. You should make sure you know what their rights are and that you abide by them. If you don't, it's not just that they can go see a lawyer and sue. They don't need a lawyer when it comes to ESA. They go to the Ministry of Labor, and there's an investigator that they don't have to pay for who's going to dig into this for them and make an order. So the ESA minimums, those standards, are very important to make sure you're meeting those. And the other question is, what are common things for companies to overlook when implementing ESA legislation, and how do we avoid this? If that means policies, when I'm reviewing policies, I'll say the more complicated, the more complex the policies get, the more likely it is we're not onside the Employment Standards Act. So when I see a policy manual come in for review, some people try to make it really complex. And some of this stuff is not simple. Some of the stuff is more complex, but I'll say the simpler you can explain it in a policy, the better. The Ministry of Labor does a good job on their website of setting things out and having examples, right? So if you're not clear about something, that's somewhere you can go for the minimum standards. Globally, for employment law generally, ESA is a small piece of that. They're not going to be able to help you at all there. But the ministry website is a good place to start, at least. They're not going to cover every situation. You're going to have some funny situations arise where you don't know what to do, and that'll require someone to look at the legislation for you. Okay, so that's all I had for questions. Anything else? Yes?
I don't know if you'll necessarily have an answer, but the change, you mentioned yourself that most of the changes that were put in were very favorable to employees, and then now a lot of those are being repealed. Why do they think that?
Well, that's a political question.
Right.
So it depends on what the Progressive Conservatives and Doug Ford wanted to do. And this is not me talking as a lawyer, but just as a citizen. I observed what their policies were, and those governments tend to be more business friendly. And I believe their platform was they're running a platform of trying to reduce costs for businesses and making Ontario open for business. So that's how they believed they would help in that endeavor.
I have a question, actually.
Yes.
So we have about 45 employees, and everybody has a policy and procedure book. And I remember last time we were at one of your courses, I don't realize that every employee additionally needs to have an employment contract plus their policy and procedure.
Mm-hmm.
So, okay, so that was my first thing. I just wanted to verify that because we were at another course with the Ministry of Labor, and we're like, we were talking about employment contracts, and they're like, oh, there's nothing in the ministry that says they need to have an employment contract, just they need to know what the policies and procedures are, or
Yep.
yada, yada, yada. So I was like, oh, you guys said yes, they said no. So,
Well, for different reasons.
right, I understand
Yep.
that part. So, because of all these new changes, and we're constantly updating the policy and procedure book, do I have to reissue new policy and procedure books all the time, or can I just keep adding amendments to?
You can add amendments to them as long as you're not altering a fundamental part of their compensation or their working conditions.
Sure.
If you're altering the manual because you want to make sure you're complying with the law, there's nothing they can do about it. It's not so much a contractual issue, that's the law. The little situation we're going to have here potentially is, with these changes, is if you want to roll back some of those paid emergency leave days, now you've got a policy that sets out certain things. That's going to be affecting, I'll say a pretty substantial benefit that they might have.
And in my policy book, I don't need to say, well, you get 3 sick days, or you whatever. I have my poster up, and they can educate themselves, right?
That's right.
I don't need to tell
Yeah, and certainly if you're going to offer them some entitlement, right, it's a good idea to have a policy about how they trigger that entitlement and making it clear what your expectations are. One of the things about having policies and contracts is if they're not clear, if they're not clear in setting out what their entitlements are and what their obligations are, they're not even worth having half the time. They cause more trouble than anything. But having a properly drafted policy and a properly drafted employment contract can really help out down the road when you have a problem with an employee. What the Ministry of Labor was saying in that situation is, they don't care what the employment contract says because they're enforcing the law, and if there's a contract or a policy that's offside, it's void anyway. So they can do whatever they want regardless of what the contracts or the policies say. A couple of things they're looking for in terms of policies as well is workplace harassment, workplace violence, occupational health and safety, right, depending on what kind of industry you're in. And so making sure you have those, that's the law. And then if you have policies that are, cover employment standards like vacation or leaves, that kind of thing, they can certainly look at them and tell you, whether they're outside the law or not.
Now, what happens if you have an employee who's under the age of 18, like start working at 16, really, for us, who can start working at
Yep.
16, can they sign an employment contract, or can they sign a policy and procedure book, or because they're not theoretically an adult?
Yeah, so 18 is the age. That's not a question I've looked at recently. My thought is you probably need an adult to sign on their behalf, but I'm not 100% on that one. Yep. Okay, well, if that's it, thanks everyone very much. I hope it was informative. If you look at anything in employment law this year, the 2 biggest things are going to be the Employment Standards Act changes and cannabis legalization. So hopefully you got something out of that. At the very least, you know what the issues are, you turn your mind to it and figure it out later yourself or maybe with the help of a labor and employment lawyer. Thank you.
It's not directly related to the ESA update?
How about after the presentation? Sure.
Thank you.
No problem.